Yes, good morning, new friends and old friends. I hope you are all in good health and in good spirit in the context of the continuous promotion of better protection of refugees, asylum seekers, and asylees. I made some points of reflection which you may wish to take into consideration. As we all know, forced displacement of people, internally or externally, including refugees, keeps increasing dramatically every year. If 6 years ago there were only 65 million people were forcibly displaced, including 21 million refugees, last year in 2020 there were 80 million forced displaced people, including some 30 million refugees. On the other hand, destination countries become more and more reluctant to admit refugees for permanent settlement, while non-destination or transit countries have to host more and more refugees and asylum seekers for a longer period of time, which may become permanent. Non-destination or transit countries are not prepared to resettle the refugees concerned permanently therein. Causes of refugee situation are no longer the strict meaning of well-founded fear of persecution for reason of race, religion, nationality, membership of particular social group or political opinion as set out in the 1951 Convention and the 1967 Protocol and the Statute of the UNHCR of 1950, but now mainly uh, internal armed conflicts, violence, terrorism, national insecurity, and persistence of gross violence of international refugees, international human rights law are the main causes of the present refugee situation. And I predict that it would be also in the future. Since 1956, in almost all cases, first countries of asylum have to deal with refugees en masse, mass refugees, no longer with individual refugees. Permanent settlement in third countries has become more and more difficult. Local integration is not the policy of non-destination or transit countries, and voluntary, safe, and dignified repatriation is not feasible because the political condition of the country of origin of the refugees are not conducive to the safety, security, and respect for human rights and fundamental freedoms of the returnees. In view of the very situation I just referred to, the international community is faced with the most difficult problem in history on how to find rational, realistic, practical solutions for the refugee problems, which means basically problems of social and humanitarian nature of concern to the international community. The 1951 Convention was designed, as we all know, to respond to the situation in Europe after the Second World War and to deal basically with individual cases. With the adoption of the 1967 Protocol, the provision of the 91 Convention becomes applicable to any refugee situation in the world. However, the basic feature of the 1951 Convention, namely an instrument to deal with individual cases, remains unchanged. It was not meant to deal with refugee en masse. As I earlier mentioned, current refugee situations are caused by threat to the safety and security of a large number of people, resulting inter alia from internal armed conflicts, violence, terrorism, national insecurity, and persistent gross violation of international refugee law. It could be noted, therefore, that the definition of the term refugees set forth in the 1951 Convention as amended by the 1961 Protocol has now been de facto expanded to include people who left their country of origin or habitual residence to save their life and or their most basic human rights and fundamental freedoms. In order that the definition of the term refugee would also cover such category of people, strictly speaking, the 1951 Convention and the 1967 Protocol would have to be amended. However, considering the prevailing international politics, no country cannot be expected to initiate to propose the amendment of the 1951 and the 1967 instruments. This lacuna can be filled out by national legislation. Talking about the situation in ASEAN, we may, as you all know, of the 10 members of the 10 member states of ASEAN, only 2 are parties to the convention and protocol, namely Cambodia and the Philippines. Indonesia is not expected to accede to the convention or protocol. Efforts have been made since all this 40 years ago, since 1981, but there is no indication that Indonesia would accede to the 2 instruments. Nor does Indonesia have a national law on refugees. In the context of ASEAN, it may be mentioned that ASEAN, as a sub-regional organization, does recognize the right of everyone to seek and receive asylum in another state in accordance with the laws of such state and applicable international instruments. This provision is contained in the ASEAN Human Rights Declaration of 2012. The stipulation that reads, in accordance with the laws of such state, reflects the position of ASEAN member state that they do not want to have an ASEAN sub-regional instrument on asylum and refugees. Indonesia does have a legislation on technical, operational, and administrative aspect of the handling of the problem of asylum seekers and refugees, namely the President Regulation 125 of 2016. It is enacted to implement the provision of Law Number 37 of the 1999 of Foreign Relations, which stipulates that the principle of policy on refugees shall be set forth in the President's decree, now called Presidential Resolution, which the enactment of Law Number 10 of 2004 as amended by law on the same subject, number 12 of 2011. To be noted, however, that Presidential Regulation 125 of the year 2016, I just referred to, does not spell out the principles of policy on refugees as required by Law Number 37 of the year 1999, Article 27, Paragraph 2. The President Regulation 125 of 2016 stipulates in fact, administrative, tactical, and operational provision on the handling of refugees, not on principles of policy on refugees as meant by Law Number 37 of 1999 on Foreign Relations. Legislation on the principles of policy on refugees to be enacted to follow up on Law Number 37 of 1999 was intended to fill a lacuna in Indonesia's legislation on refugees, considering that Indonesia did not at the time and does not have at present national law on refugees. There is no indication, as I mentioned earlier, that Indonesia would accede to the 1951 Convention and or 1967 Protocol. To be further noted that the provision of Article 26 and Article 27 of Law number 37 of 1999 on foreign relation have been, in fact, in the meantime, superseded by the provision of Article 28 of Law number 39 of 1999 on human rights and Article 28G, paragraph 2 of the 1945 Constitution, amended the Second Amendment of 2000, which recognized the right of everyone to asylum. Accordingly, the legislation which should be enacted would be law on asylum and refugees to implement the provision of the relevant provision of the Constitution as amended and law number 39 of 99 on human rights, which would elaborate in more details the basic principles relating to asylum and refugees. The relevant technical, operational, and or administrative regulation could be spelled out in lower level legislation such as government regulation or presidential regulation. Now, what would be the refugee situation in the future, and what would be the appropriate response to face such situation? I think we are now, the international community at present is faced with and will be facing the following realities. The first reality is that the number of asylum seekers and refugees will continue to rise, not diminish. Neighboring countries of the countries of origin of the asylum seekers and refugees will continue to be burdened by the influx of asylum seekers and refugees. Less and less asylum seekers and refugees would be admitted by the countries of destination. In most cases, voluntary, safe, and dignified repatriation could not take place because the root causes of the problems continue to prevail, namely persecution, internal armed conflict, violence, insecurity, terrorism, gross and or persistent gross violation of the human rights laws. And in this context, it might happen that in the case of Afghanistan, to mention one example, voluntary returnees might have to forcibly forced to leave their country again to become refugees for the second time. More and more asylum seekers and refugees has become unwanted de facto resident in the first countries of asylum. In view of the rather bleak forecast of the situation as I just referred earlier, the international community should be prepared to face the worst case scenario. That the problem of refugees will become worse in the future. The majority of them would have to stay permanently in the first country of asylum. And then the first country of asylum would have to continue to host them for a long period of time or even permanently. And the last is that humanitarian in the world is at present facing a crisis of humanitarian nature as a result of the continued refugee problem, which could not be solved satisfactorily through the basic classic ways, namely voluntary repatriation, local integration, or resettlement in a third country. Nonetheless, the problem of refugees are essentially of a humanitarian nature. To solve, at least partly, the problem, the following humanitarian approach may be considered. First, traditional countries of destination would continue to take refugees for permanent resettlement, even though for a reduced number. Number two, non-destination and non-first asylum countries would offer possible admission to refugees. Number three, non-destination countries or countries of first asylum would allow refugees concerned, or at least part of them, to settle permanently in the countries concerned. Number four, voluntary, safe, and dignified repatriation would continue to be promoted, considering that the right to leave one's country and return thereto is a part of human rights. And finally, as the problem of refugees is of concern to the international community as a whole, those countries which do not admit refugees, either temporarily or permanently, would continue to contribute financially for the international efforts to seek possible solution to the problem of refugees. The 91 Convention and 1967 Protocol are the most basic important of international refugee law. They are international instruments of peace and cooperation. Despite their shortcomings, they continue to be the most useful as a framework to promote international cooperation to deal with the problem of refugees. Accordingly, states which have not as yet become parties thereto should accede to those instruments. And at the same time, countries which have no national law with respect to asylum seekers, and refugees, such as Indonesia, are recommended to make one which would respond to the new situation of refugees by taking account the new root causes the of the problem of refugees. I thank everybody, and I hope this would be a very humble contribution for the discussion. Thank you very much.